It's file 25-7109FH. Counsel, you want to state your appearances, please?
County prosecutor.
Daniel Hartman on behalf of Mr. Coggins.
All right, good afternoon, and we're here for sentencing on interfering with electronic communications, habitual third with a 4-year maximum, and domestic violence, 93-day misdemeanor. Advisory guidelines at 0 to 16 months. Have you had a chance to review that report with your client?
Yes, we have, Your Honor.
Any additions, corrections?
No, Your Honor.
Any scoring challenges?
No, Your Honor.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Mr. Hartman, go ahead with anything you want to say in your client's behalf.
Your Honor, the first thing I want to point out is that as the court could see, the agent did a good job of putting in both versions of the event of what occurred. Mr. Coggins pled guilty. He admitted what he did wrong, but there are some mitigating factors in his story that are important, including the sequencing of the phone and the fact that even though she had kicked him and that when he struck her was after the kick, it wasn't in self-defense and it was wrong. That's how he pled guilty. And I submit, Your Honor, that this is a circumstance where he has a horrible history. He is a great employee. He's got a lot of support in the community. He is supported here today. And what occurred on the morning of for Mr. Coggins is she woke up, she was mad during the fight. He broke her phone. Subsequently, he went out to the car. She followed him out. That's where the altercation occurred. And when she was leaving after she had kicked him, that he struck her. Mr. Coggins had asked me this morning to let the court know that he knows what he did was wrong. He knows it's a crime and he knows there's no excuse. And Your Honor, I think a lot of this was taken into account in the negotiated resolution of the case. I would ask the court to look at the circumstances of what occurred. And we understand that he is going to go to jail today. He is prepared for that. Your Honor, I don't know what the court's work release plan is or program, or if he's eligible for any other programming. And we would ask the court to consider imposing a county jail sentence as recommended and the court to review the term. Obviously, Your Honor, we know that he's going to get the 93 days on the domestic violence. And this is his first conviction related to a telephone communication device. And Your Honor, the circumstances of this case are such that the parties have now separated. They no longer reside together. There was a period of time while he's been on bond in which he has had 0 infractions. He's been gainfully employed. He's been working. I know he submitted a packet to the jail for work release, and there is some indication that the jail may not allow work release because of the assaultive nature of the crime, at least during the first 93 days. And I would ask the court.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Up to this point, the defense has acknowledged that the defendant accepted responsibility, while also asking the judge to consider the circumstances surrounding the incident, his employment, community support, and good behavior while out on bond. They're hoping those factors persuade the court toward a local jail sentence instead of something more severe. But sentencing hearings are about much more than apologies. They're about balancing accountability, public safety, and the defendant's criminal history. With the defendant now preparing to address the judge personally, this next moment could carry real weight. Do you think a sincere apology should reduce a sentence when someone has a long criminal record? Or should prior history outweigh everything else?
We recommend his behavior was unacceptable. There was some provocative circumstances that don't mitigate his bad choice and don't address his criminal behavior. But I do ask the court to give him the maximum on the domestic violence and to set an appropriate sentence on the first phone charge, Your Honor.
Okay, thank you, Mr. Hartman. Mr. Coggins, it's not required that you would make a statement here today, but it is allowed. Is there anything you want to tell me, sir?
Yes, I'm very sorry for what happened. I feel bad and horrible. I know things shouldn't happen the way they did, but I'm going to move on with life and be better.
Okay, thank you. Thank you, Mr. Coggins. Mr. Hartman, if you could please go back to the table.
Oh, I
so
apologize,
that-
Your Honor.
That's fine, so that
Oh.
the prosecutor can be seen to make the statement.
Just stand in front of you, Chair.
All right, Ms. Goodrich, any recommendations from?
Thank you, Your Honor. We are here because on October 20th of 2025, the defendant hit the victim, causing a visible cut and bump on her head. When she arrived to work that day, a coworker called 911 for her. When law enforcement arrived, she was visibly shaking and crying. She had believed that she had lost consciousness after the punch in the back of her head that knocked her to the ground. The defendant had also broke her cell phone. I believe that the victim was honest about, with law enforcement, about some of the back and forth interactions between her and the defendant that day. But she was the one who tried to leave the scene, and he pursued her and used his size and strength to his advantage. The defendant is 45 years old. He was 14 at the time of his first arrest. He has 2 felonies and 14 misdemeanors and quite an significant assaultive history. We have the 1994 assault, the 1994 sexual assault, 1995 assault, 1997 assault, 1998 assault, 2 of them that year, 2000 domestic violence, 2001 assault, 2002 resisting, obstructing, and assaulting law enforcement, 2003 domestic violence, 2017 2 counts of domestic violence, and 2018 a domestic violence third. And here we are again in 2025 on a domestic violence charge with interfering with electronic communications. The defendant has been in jail 8 times, prison 1 time, probation 6 times. The guidelines are 0 to 16, giving the opportunity for the court to sentence him locally or send him to prison. The PSI recommendation is for local time at 12 months with credit for 3 days. Given his criminal history, I ask the court to do top end of the guidelines. Thank you.
Thank you. Mr. Coggins, you're 45, you've got prior felony history and extensive misdemeanor history, and as the prosecutor outlined, a fairly extensive assaultive history. The agent that prepared the pre-sentence report said this is the 6th time you've been convicted for a domestic assault. In 2018, you went to prison for one. And that makes it hard that here that there is, as acknowledged by you, your attorney, and the prosecutor, there was some physical interaction between you and the complaining witness. That certainly is a mitigating factor. But also then, she's trying to leave the situation and you're pursuing her and striking her. And I guess nobody's provided me with a criminal history of the victim, which would be highly unusual, but my guess would be that she doesn't have 5 prior convictions for domestic assault. Yeah. I don't know. I mean, the tricky thing too here is, the domestic violence. If
This is one of the most important legal moments in the hearing. Notice how the judge isn't simply deciding what punishment feels appropriate. He's explaining that sentencing guidelines and the plea agreement limit his options. Even though he openly says prison may seem justified based on the defendant's repeated domestic violence history, the reduced charge places the case in a guideline range that starts with a presumption against prison. That's why judges must carefully justify any departure from those guidelines. What do you think? Should a defendant's lengthy history carry more weight than the sentencing range created by a plea deal? Or should judges strictly follow the legal framework?
You've been convicted of a domestic violence third. We're on an E grid, a class E felony, and you would almost certainly have a prison outcome from that. the charge bargain to the interfering with electronic communications, even preserving the habitual notice, that's a class H crime. So I'm looking at an intermediate sanction cell, which has me start off from a position of a presumption of no jail at all, unless there's reasonable grounds for incarceration. I think there are reasonable grounds for incarceration in this case, as outlined in the pre-sentence report. Continued history of assault on domestic partners, the extensive assaultive history. And even though the criminal history is taken into account, it doesn't adequately take into account the similarity of that criminal history. So there's certainly grounds for incarceration. But really, with it being an H grid, I mean, the case is pled down to an H grid with an intermediate sanction cell, so that for me to sentence you to prison, Mr. Coggins, would be for me to go on the top end of those guidelines, which would not take into account any of the mitigating factors, which I don't think they're as mitigating as you think they are, but there's some mitigating factor there. So it's tough for me to see how on a 0 to 16, I can give you 16. So taking all those things into account, I mean, I don't disagree with the prosecutor that I think, given your history, Mr. Coggins, you probably deserve prison, but I got to be able to find something here that I got to follow the law of the Michigan sentencing guidelines and the recent laws about intermediate sanctions as well. Taking all those things into account, there's $118 in state cost, $130 in a crime victims assessment, and court costs of $350. On the domestic violence charge, I'll order you serve 93 days jail with credit for 3 days previously served. And on the interfering with electronic communications habitual third, I'll order that you serve 12 months in the Sheboygan County Jail, give you credit for 3 days previously served. I'm not going to allow you any work release program, but I will allow you to participate in cognitive behavioral therapy in the jail if you qualify for that, and you can earn a little bit of time off your sentence that way. In any event, that's the sentence of the court. It's within the advisory guidelines. I think I have placed on the record my reasons for incarceration despite the 0 in those guidelines. If you want to appeal, you can file an application to the Court of Appeals. If you want a lawyer appointed, you'd have to ask within 6 months. We're going to hand you a piece of paper explaining that, ask you to initial one copy for us, and the other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Coggins?
No, sir.
Okay, you're not on probation to me, so once you're done with that sentence, you're not on paper. Okay. Yeah.
Your Honor, I apologize about late. It's a 3-hour drive.
Okay. Oh, that's right. I forget that you're not up here anymore.
Yeah.
Okay. Well, good to see you.
Thank you, sir.
All right, Mr. Kukeski, we can recall Ms. Abbott's case.
Thank you, Your Honor.
Okay, Ms. Abbott, your plea will be withdrawn, bond will be continued, and we'll schedule this for a docket call for, and we'll have that docket call be a plea and motion cutoff, and we'll pick a firm trial date at that time. So let's, I mean, we could come back. I've got a docket next week on the 9th. We could just gives you guys a couple of, a few days to see if there's anything else that you want to do, given what I've said here today, or if you want to schedule it for trial, and then on the 9th we can do that. And Ms. Abbott can appear by Zoom for that, and you can too. That's no problem. You available next Tuesday?
I'm not sure. I don't have a phone. My phone's inoperable right now. So
Okay. Well, let's schedule this for next Tuesday, June 9th.
that's a problem. I can let the court or prosecutor know.
Yeah, but don't wait for the mail. It's just next week. So
I understand, Your Honor.
I know the mail won't get to you. So next Tuesday, July 9th at 1:30, Miss Abbott, you can appear by video as you have previously. And we'll, at that date, schedule it for a trial if we need to do that. Okay.
Thank you.
All right, thank you, Mr. Phillips. All right, and Mr. Philippa, we can recall People v. Sam Hill. And in this matter, I had announced a sentence that was beyond the terms of the sentence agreement and passed the case to allow Mr. Hill to discuss his options with counsel. And Mr. Philippa, do you know how he wishes to proceed?
I do, Your Honor. Mr. Hill is willing to allow the court to modify the terms of the plea and sentence agreement, whereby he would be asking to surrender tomorrow morning to the Sheboygan County Jail to serve his sentence. I believe he's grateful for the opportunity, and I fully expect his mom and dad.
This hearing highlights just how complex sentencing can be. The judge carefully weighed the defendant's guilty plea, expressions of remorse, mitigating circumstances, and extensive criminal history before ultimately imposing a county jail sentence that remained within Michigan's advisory sentencing guidelines. The court also denied work release but allowed participation in cognitive behavioral therapy, emphasizing both accountability and the opportunity for rehabilitation. It's a reminder that sentencing isn't driven by emotion alone. It's shaped by evidence, legal standards, plea agreements, and judicial discretion. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I drop him off at the jail steps tomorrow morning.
Okay. All right. Well, Mr. Hill, the sentence will be as the court announced, which is the 10 months in the jail with the credit for the time that had been served. I will allow you to report to the Sheboygan County Jail tomorrow morning at 9 a.m. And then within 24 hours of your release from the jail, we'll have you report to your probation agent and we'll begin those probation services. I will indicate that if Mr. Hill is eligible for it, I would approve him for participation in the jail in the cognitive behavioral therapy class, as well as trustee status if the jail sees fit. Then you can earn time off your sentence that way, Mr. Hill. Okay.
Would the court see fit for work release?
I think not on a domestic thing. So that's the sense of the court, Mr. Hill. If you wanted to appeal, you have to file an application with the Court of Appeals. If you wanted me to give you a lawyer, you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that process to you. Ask you to initial one copy for us. The other one's for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Hill?
No, sir.
Okay. Good luck to you.
Your Honor, can I supplement the record just briefly?
Yeah. Yes, sir.
Mr. Hill, you understand as the judge mentioned, you have the right to withdraw the plea and we can start over at the trial? Yes. But you also don't want to put your ex-wife through this? Correct. And you understand that you've done wrong in your life and that the judge is not bounds for this? Right. Okay. Nothing else, Your Honor.
Okay. Thank you, Mr. Filippo. Now, Mr. Hill, until tomorrow morning, those bond conditions continue, including no contact. So, I mean,